Welcome to the Republican Professor. I'm your host, Dr. Lucas J. Mather. Today is 29 August 2025. It's a Friday, 2025 years after Jesus. I have uh I have to interrupt our regularly scheduled broadcasting to introduce an issue that has been decided by the 10th Circuit Court of Appeals enjoining enforcement of a 7-day wait in New Mexico to purchase or transfer a firearm. Um, and before we get to that, we're gonna hit that pretty hard this I almost said this semester. I've had coffee. I don't know why I'm having an issue here. I'm having some brain fog all of a sudden, but we're gonna hit that this episode. And so you'll have a firm grasp of what the 10th court decided, who was on the panel, and what the electoral implications are for this. It is good news. It's great news. So it's a fun episode for me to do today. It's one of those episodes I wish I could do every day. But um, I also wanted to briefly tell you about some new programming that I have in mind coming up in the fall. And that will be the backstory of TRP, the Republican professor, it'll be pretty much for YouTube, although I will post it on the audio onlys. But it will be using some props for you to see, namely my iPhoto, my iCloud photo from the years prior to the launch of the podcast to give you a sense of what it was like for me on campuses and how I interacted with people, how I was treated, and what was happening on the campuses that I was teaching at in LA, the lessons I learned from that, and then why I launched with the help of some friends. And I couldn't have done this without these friends of mine. I couldn't have done it. Okay. So I want you to know this is not just me behind this. There are people that have come alongside of me to help. And I just want to give you a sneak peek into some of that backstory. It's not going to be exhaustive, but what I'm doing is I'm downloading my photos from iCloud because I am old school and I don't want my photos just hanging out there on the cloud where I have to have a password to get to them or, uh, you know, it's a matter of I want them in a physical album that I can have. Okay. So I did a lot of documenting with my photos of life on campus and documenting discussions I had on Facebook, and I would take screenshots so that I would remember later. Um, and so that I'm going back through, like I just went through 2017, the spring of 2017, yesterday, and uh, there was some connections about the Republican professor that go back years to the spring of 2017. And I was making connections like, wow, yeah, that's where that came about. That's where that concern came about. Um, so anyway, I don't know if it's going to be interesting to you, but I feel like I have to document it. And I hope it's interesting to you. In any case, if it's interesting to people that are taking this project seriously, the material will be there for you so that you don't have any confusion about it. There's no misunderstanding. And I think actually the truth about the backstory of the Republican professor, I think is interesting. Now, I mean, it happened to me. So, maybe I'm biased, but I actually think that it might be that people don't quite understand the reality, and maybe they don't want to. Oh, okay, fine, whatever. That will be some programming that starts in the fall. So we're getting into the fall. Now, you've noticed, if you have noticed, if you're paying attention, I'm going to share my screen. Feel free to call me Sharon. If you've noticed, the way I'm doing the podcast ever since we started, we took a break from interviewing people. It's not that we're not going to go back to that. It's just that I'll talk about that on some of the backstory. But I wanted to point out that we have covered the waiting period topic on the Republican Professor in some detail. How do I know? Well, for those of you on YouTube, you can obviously see I'm on the YouTube channel right now on videos. And if you take this little search button right here and just search Ishii, Ishii, that's the name of a Democrat judge that stood up for the Second Amendment for us in California, a federal judge who was appointed by Clinton. And I covered his decision in detail, the 10-day waiting period, in several episodes. Now, you can see these episodes. I don't know why this class one comes up. I'm not sure. Maybe did I mention him? I don't know. But you might not be able to see this. I don't know. But anyway, don't pay attention to the class one. Um, these are the episodes on Ishii right here. And it's all about the California 10-day waiting period and how this federal judge got it right. He was a trial judge and he got the answer right. And I applaud that. I'm excited. When I see a Democrat get it right, I'm like, yeah. And by the way, the the defendant in that case was Kamala Harris when she was Attorney General. Sylvester versus Harris. It was a Democrat was slapping down Kamala Harris. This is back in 2014, I think. So now the Ninth Circuit overturned that judge wrongly, in my correct opinion. So the Ninth Circuit at the time said, yeah, we make the Second Amendment say whatever we want it to say. That's not what this Democrat judge was saying. The Democrat judge had respect for the Second Amendment. And anyway, if you go, these are a resource for you. One of the things I said was I noticed that if you look at what's her name? Not Wendy. Toch. I'm gonna search Toch real quick and see what comes up. There, I can't remember how to say her last name. Okay, Wendy. Okay, it is Wendy. Wendy Tochihara. Her parents she came on the podcast episode 35. There it is. If you're on YouTube, you can see what I'm looking at. I interviewed her, me and Curtis, my co-host Curtis, and her parents were interned in a Japanese internment camp during World War II. I made the connection that this guy Ishii had been interred in a Japanese internment camp during World War II. And my thought was he was a little bit more sensitive to violations of civil rights than maybe your average Democrat. I could be wrong about that. I'm not so sure. I could be wrong. But I was struggling to figure out why this Democrat judge broke from the crowd and upheld the Second Amendment in California. And that's what I came up with. He had his civil rights stripped away from him. Now, why in the world he chose to be a Democrat. He obviously took a wrong turn somewhere and didn't wasn't connecting the dots on some things. Maybe I don't know. I mean, I can't. I didn't interview him. He's probably a very thoughtful guy, and maybe people are insulted by what I'm saying right now. But I'm just trying to figure out. I'm just telling you what I really think. I'm not trying to insult anybody. I'm just trying to say that this guy, Judge Anthony Ishii, got the answer right at the trial court level in California. And Kamala Harris was the defendant. And historically that's very significant. It's very significant. Now what just happened? What just happened at the 10th Circuit? Now this is just 2 weeks ago. It's not even 2 weeks ago. I'm sharing my screen again. Feel free to call me Sharon. Here it is. I'm shining it. Publish United States Court of Appeals for the 10th Circuit. 10th Circuit covers my home state of Colorado. Colorado. Guess where Gorsuch came from? The 10th Circuit. Guess who's on the panel? You're going to be very interested in this. At least I think so. I'm interested. Guess who's on this panel? Oh, yes. Timkovich, Matheson, and EID. Every time I see this, I think of Navy Special Warfare, but it's not EOD, it's EID. Anyway, sorry, stupid joke, but it's not really a joke. But Timkovich was Gorsuch's motivational speaker when he was getting confirmed through the Senate. Timkovich was the senior judge in the 10th Circuit. It was the chief judge of the 10th Circuit when Gorsuch replaced Scalia. Scalia, as you know, wrote the majority opinion in Heller versus DC versus Heller, and the Heller won, and um, Alito wrote McDonald. So, but Scalia stood up for the Second Amendment back in 2008. Gorsuch took his place, and Timkovich was. I was trying to get a handle on who Timkovich was. Timkovich was appointed by George W. Bush, okay, Republican. And then EID, this EID lady, was appointed by President Trump to replace Gorsuch. Who's this guy Matheson? This guy Matheson is the dissenter here. Okay. So his opinion is in dissent because it's a 3-judge panel, 2 out of 3 wins. Matheson was appointed by Obama, I believe, Democrat. When I originally saw this, I was like, okay, it's before Timkovich, Matheson, and EID. I think her first name is Allison, EID. Is Matheson on the correct side? Did an Obama judge come over again? Because we just had an Obama judge come over in the Ninth Circuit and get the right answer on the day 1 in 30 rule that they threw out for purchases of guns. You can only buy one gun in 30 days. It was a bullcrap rule. Well, an Obama judge came over to our side on that, and that was incredibly encouraging. Did a podcast episode on that recently. I'm going to share my screen, go over to Chrome, and show you where that is. If you go to videos and you go down to right here, 2 weeks ago, right here, you'll see that fits. You'll see, when was it? August 10th, right? Oh, sorry. Man, you'd think I would know my own material here. Obama judge. It's got Obama judge in there somewhere. If you search, oh, there it is. 2 months ago. Wow. Okay. I'm officially June 25th. Wow, June 25th. That's how long ago it was? Man, I guess the summer went pretty fast. When I do a lot of deep work in the summer, and sometimes it can get away from me, and I lose track of time. I do a lot of deep work in the summer. Okay, well, June 25th, Second Amendment update, an Obama judge, Ninth Circuit judge just joined Trump judges against California. That's the episode there. It's an hour long, and we were cruising in that hour long. Okay, so I'm just pointing out this channel is not haphazardly thrown together. There's things that are going in tandem. They're going parallel lines at the same time. So I'm doing series one after another, and then when that series is done, I start a new one, and I'm still doing other series, and then when those are done, I start a new one. So I might have four or five different topics happening at the same time. They're obviously not in the same episodes, but they're happening in tandem. And so I'm always thinking ahead, what's the next topic? So that's how I do it. I do it like short classes where you can get, if you want a 10-day waiting period update on some of the issues historically, you can go to Ishi's and you've got 4 or 5 episodes there. You can do a deep dive on that and you will be an expert in it. Why? Why do I know that? Because we actually read the damn thing. It's not me summarizing and then coming in here and editing, editing any like dead space, because you have such a tiny attention span. So, my face is down here and then it's up there, split second later. That stuff drives me nuts. And I think as we go forward with AI and uh, the number of people getting on YouTube, there's 20 million of these suckers that are uploaded every day or every week. I can't remember, but it's some crazy number. On the other side of that, in the podcasting world, you're in the top 50% of podcasts if you do your fourth episode. Why? Because so many podcasters quit. And why do they quit? That's because there's so much noise and most of it is bull. Beep. It's fake. It's stupid. There's no depth. You have to do a lot of editing if you have nothing to say. What do you, if you have something to say, why would you edit anything? Just say what you need to say, like John Mayer said. On that note, let's get into it. Yes, this 7-day beatdown. Oh, the now we have a circuit split. That's where I'm going with this. We have a circuit split on 10-day waiting periods. I'm sorry, on waiting periods per se. In and Timkovich, man, I'm proud of this judge. Timkovich and EID, Bush and Trump. What do they have in common? Bush and Trump. Republican. You need to drill this through your skull. Republican. Are the Republicans perfect? I never said they were. If you listen to this podcast, you'll hear the exact opposite. 2 episodes ago, I was excoriating Gorsuch the entire time. And that's a multi-part series where I'm tearing Gorsuch apart. Uh, Gorsuch gets it right on guns, and he might get it right on VA stuff too. I'm going to do I'm going to do probably 1 or 2 episodes on veteran affairs because I'm dealing with veteran affairs right now, and my heart goes out to veterans that try to struggle through this bureaucracy, and then they try to deal with all these other monkeys trying to, make a buck off of them while they deal with the bureaucracy. Something's really wrong here with VA stuff. And I'm a veteran and I can't stand it. And so I have to say something. And Gorse, there was a recent Supreme Court decision on this back in March, and there was a split on the Republicans. And so I'm gonna probably cover that on the podcast. It has to be covered on veteran affairs. So I call the balls and strikes as I see them. And I if I'm a Republican, I tell you I'm a Republican. I don't shy away from it. I just say that's what I am. So it's not like I don't know why people act like it's some kind of, then all of a sudden I have some kind of an agenda. You have an agenda whether you say it or not. It's not, you know, the agenda thing is so weird. I don't know why people just, you call yourself a Republican, and they act like you're getting paid by the Republican Party or something. I'm not getting paid by anybody. In fact, I'm paying to do this. Okay. I'm taking a chunk out of my financial ass to do this because I believe it. Hello, hello, back to basics here. Back to basics. You want to know what my agenda is? To say what I believe. And I believe it after watching and studying and seeking to understand for a long time. Okay. This is part of it. I actually read, and I encourage you to read. No more bullcrap. Just sit your butt in the chair and read. It's hard. Back to basics is always hard, but this one is going to be fun because we have a circuit split. The 10th is disagreeing with the ninth, and I'm excited about that because the Republicans have it right. And the daggum Democrat, he could have come over, Matheson, but he didn't. And if he did, I would celebrate that. And I would point out, look, he's a Democrat. He did something right. Good. Take it for what it is. Okay. So, Matheson, you screwed up, dude. Timkovich and EID, Allison, you did it right. New Mexico enacted a law in 2024 that imposes a categorical 7-day cooling off period for nearly all consumer purchases of a firearm. So starts Timkovich in 10th Circuit. This is how's this styled? Ortega versus Grisham. Okay. There it is, August 19th, 2025. If you search, um, you know, 10th Circuit 7-day wait, it'll come up. I'm on the 10th Circuit website. It's on there. Okay. So I'm on page 2. No matter how urgent the need or how much physical danger a prospective buyer might be in, buyers must wait 7 days before New Mexico deems them safe to carry arms. Even buyers with previous firearm background checks or security clearances are not eligible for waivers from the prohibition. That tells you a lot right there. And that's what Ishii nailed into when Ishii did the California version of this at the trial court. Democrat. I'm giving him major props. I did 5 episodes on the guy. In short, the law requires no individualized reason to conclude that a prospective consumer is a danger to himself or the community, nor can anyone be excused from the waiting period because of personal danger. That says a lot right there, too. Personal danger? No, we're going to control you. We're going to continue to control you. By the way, New Mexico is run by Democrats. Okay? Just saying. I know there's Democrats on our side, and I don't mean to offend anybody, but we need to help the Democratic Party get better on this. You know, I think the Democratic Party's are wrong on a lot of things. But if we can fix this in the Democratic Party, we're going to probably move the country forward, I think. I mean, maybe I'm wrong about that, but I don't think so. I'm pretty certain. Asserting their rights under the Second and 14th Amendments Samuel Ortega and Rebecca Scott sued the state of New Mexico to enjoin the waiting period. The district court declined to preliminarily enjoin the law. It found that a 7-day wait did not infringe on the Second Amendment rights, since the right to acquire a firearm does not impede the right to keep or bear a firearm, and in any case, the Second Amendment tolerates cooling off periods. Well, of course, New Mexico is going to say that because New Mexico thinks they are Mexico. They think that they're old Mexico. It's like you need to uh, set them aside and say, you see the word new in the word New Mexico? Yeah, that refers to you not being Mexico. You're in the United States, buddy. We have a U.S. Constitution, and Timkovich says we disagree and reverse and remand. Cooling off periods infringe on the Second Amendment by preventing the lawful acquisition of firearms. Cooling off periods do not fit into any historically grounded exceptions to the right to keep and bear arms and burden conduct within the Second Amendment's scope. Way to go. Way to go, Timkovich. In this preliminary posture, we conclude that New Mexico's waiting period act is likely an unconstitutional burden on the Second Amendment rights of its citizens. We also conclude the other preliminary injunction factors are met and plaintiffs are entitled to an injunction. All right. So far, so good. Legislative background. In response to a high statewide rates of gun violence, the New Mexico legislature adopted a 7-day waiting period for most consumer firearm purchases. The statute states waiting period of 7 calendar days shall be required for the sale of a firearm and the transfer of the firearm to the buyer. The 7 calendar day waiting period shall include the period required to conduct a federal instant background check. Notice the word instant in the word federal instant background check. That was me. Back to the quote. If the 7 calendar day waiting period has expired without the completion of a required federal instant background check, the seller shall not transfer the firearm to the buyer until the federal instant background check is completed. We're on the bottom of page 3, top of page 4 now. Incidentally, the reason I harp on the pages and the sources is because if you're a student or you're a parent of a student, keeping an eye on what your kid is doing, if you're a student or a parent of a student or a mentor of a student, and you want to make sure they're doing their writing and they are doing the writing, not some computer program, not some app, and it's back to basics, you got to have the page numbers right. No excuses. Sources and page numbers and footnotes. That's why I harp on this. If the background check process is not completed quickly, the waiting period can be extended for up to 20 days, at which point the seller may transfer the firearm, even if the background check has not been completed. Well, why would that be? Why is it that you can transfer the firearm without a background check after 20 days? Why would that be? I'm just going to have you simmer on that for a second. Why would that be? Why 20 days? Could 20 days be extended? Could it be shortened? Is it arbitrary? Are constitutional rights arbitrary? Until the waiting period is over, the firearm must remain with the seller or the licensee performing the background check, even if the transaction has been completed. Interesting. I think normally when you complete a transaction, you take possession of what you just paid for. Isn't that normally how it works? What could possibly go wrong? I mean, in 2020, we saw what could possibly go wrong. But what else could possibly go wrong? The statute makes it unlawful for anyone to transfer ownership, possession, or physical control of a firearm from the seller to the buyer before the end of the required 7 calendar day waiting period. Each party to an unlawful sale, transferee or transferor, is guilty of a misdemeanor if the transfer is made before the 7 day waiting period. Okay, so we're criminalizing innocent conduct, which is the worst thing a government can do. Criminalization of innocent conduct. What he just said was, I remember he's on our side, Bush appointee, George W. Bush. I know you're going to complain about Iraq, whatever, but he got this right, okay? He got this right. By the way, we did an episode with one of the defenders of the invasion of Iraq, and people gave me such crap about this. But, um, you know, I feel like I need to say that Robert Kaufman, my former colleague at Pepperdine University, is probably the best source you can deal with on that topic. And he wrote one on Obama's foreign policy. He knows foreign policy really well. And you may be wrong about some things. I'm just pointing it out. Okay. I'm Don't hate me. Don't hate me. Okay. I don't even know if you were able to see that, but um because I switched over to Chrome, but I pulled it up. The episode is the virtue of prudence in U.S. foreign policy, and it was about a year ago, September 20th, 2023. Oh, 2 years ago almost. He came to my international relations course I was teaching from Pepperdine and he came to Azusa Pacific University. He fought traffic for 2 hours to get from Malibu to Azusa. And if you know that area, you're going right through one of the most populous counties in the United States, from the far western part, which is Malibu, to all very close to the far eastern part of LA County, which is Azusa. It took him like 2 hours or an hour and a half or something. And he's no spring chicken, and he did it for free. He came out and addressed my tiny international relations course there in Azusa Pacific, just because we knew each other from Pepperdine. I mean, he's one of these guys that probably knows everybody, but I used to see him there at Malibu, Ralph's, Starbucks, the Starbucks by Ralph's, if you know Malibu. And he would be down there all the time, like Socrates, reasoning with people in the Agora. And I came up to his office a few times at the Pepperdine School of Public Policy when I taught at Pepperdine for over a decade. And he remembered me, and he came out and did me a solid. I've never done a damn thing for the guy. And he came out, and it's not like he was going to sell any books, and he doesn't make that much on books anyway. If he sold a couple books, it wouldn't even pay for his gas. So, I had my students do a card for him and thoughtful responses, and we mailed it to him in Malibu. I hope he got it. I never checked. But anyway, back to Timkovich. Remember, Timkovich is a Bush appointee, is my point. And you might hate Bush and not really know the full story. Okay. Just FYI. This is the Republican professor. I'm telling you what I really believe. Okay. I don't have this agenda is what I believe. It's my belief. I'm taking a chunk out of my financial ass to do this. I'm not getting paid to do it. It's what I believe. Okay. Let's keep going. Each party is guilty of a crime that didn't exist before. It was just made up. In other words, we're inventing crime there in New Mexico. You're inventing crime. You're inventing a crime in the guise of fighting crime. That's their MO. We're going to fight crime. We're going to try to lower crime by inventing new crimes that you can be guilty of for what was innocent conduct and what is still innocent conduct. There's nothing guilty about this. Paying for a firearm and taking possession of it. There's nothing guilty about that. Pass a background check. You pass the federal background check. Why would you have to wait 7 days? Why would you be guilty of anything except for on paper? A Democrat guilt is criminalization of innocent conduct. All tyrannies criminalize innocent conduct. Let me say that again. All tyrannies criminalize innocent conduct. That's what they do. That's what makes it an oppressive place. It's not that hard. Back to basics. If you want to understand the Republican Professor podcast, it's back to basics. Back to basics. The most fundamental errors occur all the time. They keep occurring because of human nature. Once you understand human nature, you're not surprised. Human beings are incredibly fickle and ignorant. Sometimes we get it right, and then we start getting it wrong again because we're ignorant and fickle. We make the same mistakes. We don't learn. Exemptions are made for sales and transfers between two firearm dealers, buyers who have concealed carry permits, law enforcement purchasers, and transactions between two law enforcement officers or between immediate family members. Okay, we have some exceptions there that were not applicable in California. So this law, on a few instances, was not as bad as California's 10-day wait, but still, it gets struck down. It's not as bad as California's, and it gets struck down. So this is very interesting for our purposes, especially as a California boy. You know, I didn't grow up here, but I'm a Colorado boy, so I got 1 foot in the Ninth Circuit, 1 foot in the Tenth Circuit. My background's in the Tenth Circuit. I'm right now in the Ninth Circuit. The law serves two purposes. First, it seeks to reduce impulsive gun violence or suicides. Second, it aims to close a perceived loophole. Oh, I love the word loophole. Tell me about this loophole. In federal law that sometimes permits a purchaser to acquire a gun without completing a background check if the process takes more than 3 days. Why is that a loophole? I mean, we just read that in this state law, the New Mexico law, you can take possession of a firearm after 20 days if the check takes that long. Remember I said pay attention to that? The state legislature adopted the law on February 12th. All right. Governor of New Mexico signed it on March 4th. It became effective May 15th, 2024. Factual history. The same day the law went into effect, Paul Ortega tried to purchase a handgun from a New Mexico firearms dealer. Mr. Ortega is a retired excuse me. Mr. Ortega is a retired law enforcement officer who already legally owned multiple firearms. Sounds like my kind of guy. Although Mr. Ortega paid for the handgun, now I paid close attention to how New Mexico treats retired law enforcement officer who owns multiple firearms. Although Mr. Ortega paid for the handgun and immediately passed a background check, he was subject to the waiting period and could not get his gun for 7 days. Yeah, I mean, that's what we're dealing with here, 10 days. And during what people call COVID, I never use that word. I don't say that word. I say the lockdowns because I want to take the focus off of something we don't know if it came from nature, where it came from, something that's not that has no agency, and put it squarely on humans which have agency. The lockdowns were a human thing. The response was a human thing. So we had people that were waiting 30 days, and then they couldn't get in to get the gun. They couldn't get in because the places were closed. It was a disaster. We did episodes on that. Just search Van Dyke on the Republican Professor, YouBoob, or you can go to the website and search it as well if you want. Republicanprofessor.com. Although Mr. Ortega paid for the handgun, he passed a background check. He's a retired law enforcement. Yeah, you still have to wait 10 days. You need to cool off. Mr. Ortega, why do you need this gun? You need to cool. Hey, cool off, buddy, for 7 days. We're going to just invent a number, pull it out of our rear end. 7 sounds pretty good right now. We could change it. We pulled it out of our butt once. We can pull another one out of our butt later. You see how this goes. By the way, you're a criminal if you take possession before that. Now, you could be a model citizen 1 second and then a criminal the next second for doing something innocent because we criminalize innocent conduct. Rebecca Scott similarly tried to purchase a firearm and quickly passed her background check. She too had to wait out the week only because of a cooling off period. Rebecca, you need to cool it. Cool off trying to purchase a gun for self-defense because you're in personal danger. Hey, cool off. See the victim blaming? It's not just victim blaming. Pay attention here. It's not just victim blaming. It's victimization. It's victim creating. Because now you're taking lawful people and making them criminals for innocent conduct. It's the exact same conduct. Whatever you want to say about the Ten Commandments and the religious background of our civilization, the Ten Commandments did not do that. The Ten Commandments said, do not murder, for example. Well, murder was already wrong. It wasn't that it made it wrong. How do I know that? Well, go into the text of the Old Testament, go into Genesis, which comes before Exodus. Exodus 20 is where do not murder first appears. And you'll see Cain kill Abel in Genesis chapter 4. Genesis has 50 chapters. So 46 plus 19, 46 chapters in Genesis plus 19 before chapter 20 in Exodus. 46 plus 19 is 56 plus 9, 65. 65 chapters before the Ten Commandments. Murder is wrong. It's very clear. It's already wrong. See, we go by what's actually wrong. And it's articulated in a positive law. That's the way it's supposed to go. That's the ideal way. We don't just make crap up. Okay? The Democrats are just making crap up here. They're making it up. Mr. Ortega and Miss Scott plan to purchase more firearms and brought this suit before their waiting periods expired. They sought preliminary and permanent injunctive relief to enjoin the New Mexico law. They sued the governor and attorney general and okay. Procedural history. C. Skipping down a little bit. After an evidentiary hearing, the district court denied preliminary relief on the on three grounds. First, it found that the right to keep and bear arms did not cover the right to acquire arms. Okay. Second, it found the waiting period was a presumptively constitutional commercial condition on firearm sales, carved out by the Supreme Court in District of Columbia versus Heller, 2008. Because waiting periods have existed for almost a century and their burdens are supposedly minimal, plaintiffs did not overcome this presumption. Now remember, Timkovich here, 10th Circuit, along Bush appointee, along with a Trump appointee who replaced Gorsuch on the 10th Circuit. EID. I don't know how to say her name. I think her first name is Allison, I believe. They're against Matheson, who's an Obama guy, and they're sticking up for the Second Amendment. Remember, they're just saying what the district court said. Okay. Third, the court ruled in the alternative that the waiting period fit within the principles underlying our historical tradition of regulating firearms. The district court found that historical examples denying outright the ability to possess firearms for certain demographic categories served as an acceptable historical analog. From these analogs, the court determined that the Second Amendment's text permitted waiting periods for broad swaths of society out of fear that some individuals would misuse their firearms. We're on page 7 at the top. The district court also ruled that plaintiffs did not meet other factors in the test for injunctive relief. That is, the injury was not repairable because plaintiffs owned other firearms. And the balance of equities and public interests weighed in favor of reducing gun violence. Man, there's so much wrong with this. I don't even know. I mean, I'm just going to let Timkovich say it. We're letting Timkovich shine here, and EID, the lady, the Trump appointee. Plaintiffs appeal seeking reversal. They bring a facial and as applied challenge. Okay. Discussion is where we get into the reasoning. But can you guess what's wrong here? Can you see it? My guess is you probably can. If you're listening to this, you can see it. You can see the problem here, right? Um, they owned other firearms, so the balance of equities is fine if they have to wait for another one. That's how the Democrats think. Here's how the Republicans think. They own other firearms, so therefore the cooling off period is incoherent. Give them the gun now. Why now? Because it's a constitutional right. That's why. That's why. No other constitutional right would be treated this way. They owned other firearms. Oh, yeah. So what's the point of a cooling off period? I mean, you're a witness against yourself, Democrat. You just testified against yourself. This is a cooling off period, right? That's what you said, but that's not what we really believe. We can see right through it. It's just trying to control people. And it's not just trying to control people for now, it's setting the stage for controlling people more later. That's why it's important to stand up and say no. Just like the strong-willed child, Dr. Dobson, remember that book, The Strong-Willed Child? Look it up, Dr. James Dobson, The Strong-Willed Child. You have to say no. You have to keep saying it. And that's the exhausting thing about strong-willed children is they will test your limits and boundaries all the time. And you just have to keep being firm. Back to basics. The strong-willed child is one of the best discussions of the Democratic Party ever written. And it wasn't even written originally about Democrats. It was written about strong-willed children and how to discipline them. That's what we do. Discussion. Modern doctrine on the right to keep and bear arms is shaped in large part by the Supreme Court's decision in District of Columbia versus Heller, which recognized an individual's Second Amendment right to possess firearms. But the right secured by the Second Amendment is not unlimited. This is a quote. From Blackstone through the 19th century cases, commentators and courts routinely explained the right was not a right to keep and carry any weapon whatsoever in any manner whatsoever and for whatever purpose. That's a quote from Heller, 2008. And this case represents the efforts of many states and courts to discern the Second Amendment's outer limits. A, the preliminary injunction standard. We review a district court order denying a preliminary injunction for abuse of discretion. An abuse of discretion occurs when a district court commits an error of law or makes clearly erroneous factual findings. Claims of legal error are reviewed de novo. Okay. What can I say here? An abuse of discretion occurs when the district court commits an error of law or makes clearly erroneous factual findings. In other words, this is a pretty high standard to meet. To overturn a district court, it's got to be clear. It's not like a wobbler. It's a big problem. It's a basic problem. That's the standard that they're applying. So this is kind of like a shot across the bow and saying, this is easy. This is not hard. This is easy. This was a major, basic problem, a fundamental problem at the district court. An error of law or clearly erroneous factual findings. A preliminary injunction requested under Federal Rule of Civil Procedure 65A is an extraordinary remedy that may only be awarded upon a clear showing that the plaintiff is entitled to such relief. He's giving precedent here from the Supreme Court on this rule. Okay. Plaintiffs seeking an injunction must establish, one, a substantial likelihood that they will ultimately succeed on the merits of their suit. Two, that they are likely to suffer irreparable harm without preliminary relief. Three, this threatened harm outweighs the harm a preliminary injunction may pose to the opposing party. And four, if issued, this injunction will not adversely affect the public interest. So you got four conditions for a successful injunction. And the district court screwed it up, and they're fixing it. So they're going to go through these four conditions here. When a party seeks an injunction that would change the status quo rather than preserve it, it faces a higher burden. Now, listen to this. Listen to this. When a party seeks an injunction that would change the status quo, that's this party. That's Mr. Ortega. That's Rebecca Scott. They're changing the status quo. Rather, Timkovich says it faces a higher burden. Yeah, they still met that burden. That's how bad the Democrats are. They still, yeah, make the burden as high as you want for this preliminary injunction. They easily get over that hurdle. It's not even close. In seeking such an injunction, the movement must make a strong showing, both with regard to the likelihood of success on the merits and with regard to the balance of harms. Listen to the balance of harms language, because you want to. It might be helpful for me to just point out success on the merits is one thing. What's the Second Amendment mean? Does it apply to this? Did the law get it wrong? Does the law violate the Second Amendment? That's success on the merits. The balance of harms is a second condition, though. We're going to read the rest of what he says there, and it's not that long. But I think I need to make a point here about bias and about the. I'm trying to be nice here, but I'm also just trying to tell you how it is, okay? Um, I feel like, the fruits of the Spirit in Galatians, the book of Galatians, the New Testament, the fruits of the Spirit, right? Joy, peace, patience, kindness, long suffering, faithfulness, goodness, self control. Against these things, there is no law, right? But remember this: Jesus in the New Testament, his birth, not only his birth, his conception was caused by the Holy Spirit, and he was filled with the Holy Spirit. If anybody ever was filled with the Holy Spirit, it was Jesus. Of course, there are other people too, like John the Baptist, for example. Um, but he was filled with the Holy Spirit. Okay. So everything Jesus did was the fruits of the Spirit, right? Right. If you notice his interactions with the religious leaders, the highly educated people, Pharisees, Sadducees, so on and so forth, his tone doesn't sound pleasant. But if he was filled with the Holy Spirit and he perfectly is exhibiting the fruits of the Spirit, kindness, gentleness, patience, long suffering, self control, faithfulness, goodness, joy, well, then those unpleasant tones in his voice, sometimes he's actually producing shame in public. It's not like he's going out searching for these opportunities. They came to him, but he didn't back down from it. That's kindness. That's goodness. That's patience. That's long suffering. And sometimes his long suffering looks like this conversation is over, buddy. You crossed a line. I just want you to pay attention, okay? Integrate your understanding of the scriptures. Integrate the fruits of the Spirit with the life of Jesus. Sometimes there's an unpleasant tone. Now, I'm not accusing Timkovich of this. I think he's very restrained here. But he's saying that this is a high bar, and they still went up for the dunk and shattered the backboard. What page are we on? 9 at the top. When a plaintiff is asserting an injury in the form of a violated constitutional right, we presume that the injury will be irreparable if it exists. Makes sense to me. The difficulty in calculating or determining adequate monetary damages for a constitutional injury is so well settled that the principle collapses the first and second preliminary injunction factors, equating likelihood of success on the merits with a demonstration of irreparable injury. Similarly, the third and fourth factors merge when, as here, the government is the opposing party. Sounds right to me. What are those four factors again? Substantial likelihood that they will ultimately succeed on the merits. That's one. Two, that they're likely to suffer irreparable harm without preliminary relief. Okay, if it's a constitutional challenge, you've violated constitutional rights, those two things collapse. And if one is fulfilled, two is fulfilled. That's what he just said. Three, this threatened harm outweighs the harm preliminary injunction may pose to the opposing party. The opposing party is the government. And four, if issued, the injunction will not adversely affect public interest. Okay, so 3 and 4 go together. And when you have a private party whose constitutional rights are violated by the opposing party, which is the government, well, then the public interest is not adversely affected by siding with the people who are harmed by the government. Because the whole point of our constitutional system is to preserve individual liberty. That's the whole point. Okay? It's not like, you know, an extra topping on your ice cream. You get it sometimes or so. That's the whole point. Back to basics. B, Second Amendment framework. Our Second Amendment analysis begins with the text. A well regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. This right to keep and bear arms is among the fundamental rights necessary to our system of ordered liberty. That's United States versus Rahimi, page 690, quoting McDonald, page 778. In Heller, the Supreme Court held that the Second Amendment codified a pre-existing individual right. The court adopted that original understanding of the Second Amendment. The right recognized by the Second Amendment is and held by the people today is the same common law right enjoyed by Englishmen and colonists. That historical right, however, did not guarantee a right to keep and carry any weapon whatsoever in any manner whatsoever and for whatever purpose. Rather, it is a job of courts to determine whether modern laws restricting or punishing firearm use come into conflict with that historically understood right. The Supreme Court has explained that the Second Amendment, as historically understood, protected an individual right to possession of a handgun in the home. But the court did not undertake an exhaustive historical analysis of the full scope of the Second Amendment. So the court instructed, nothing in its opinion should be taken to cast doubt on long-standing laws imposing conditions and qualifications on the commercial sale of arms. Following Heller, the Supreme Court in New York Rifle and State, New York Rifle, sorry, New York State Rifle and Pistol Association versus Bruin, and in United States versus Rahimi, cemented the approach to Second Amendment interpretation by first assessing whether a law implicated the plain text of the Second Amendment and then analyzing whether the challenge regulation is consistent with the principles that underpin our regulatory tradition. A focus on the historical principles ensconced in our tradition is necessary to apply faithfully the balance struck at the founding generation to modern circumstances. This language, the balance struck by the founding generation, is the key issue. The judges are trying to do some kind of interest balancing now based on contemporary sentiments that they have personally or they think that some part of the electorate has. But the Republicans are saying, no, what's necessary here in this jurisprudence of the Second Amendment is to get the balancing that was already done by the founding generation, the framers of the Constitution. That's what a constitution means. That's the whole point of having a constitution. Or, as Justice Barrett put it, original history plays two roles in the Second Amendment context. It elucidates how contemporaries understood the text. For example, the meaning of the phrase bear arms. It also plays the more complicated role of determining the scope of the pre-existing right. Now, this term pre-existing right is also important. That the people enshrined in our fundamental law. That's Barrett concurring in Rahimi. Under this framework, we assess the three alternative holdings of the district court. I'm going to take a drink of water here, and I'll let you catch up with your breathing. Take a bit of coffee in. Let me make a comment about the Cracker Barrel crap that happened the last week. Because I had somebody ask me, why are you so adamant about the Cracker Barrel thing? Well, it's it's a basic it's an example of a basic problem. And the basic problem is this. People are always trying to fix problems that don't exist. I mean, how much money was spent trying to redesign the Cracker Barrel logo? Seriously? See, that's exactly what I'm trying to talk about here. That's not a problem that needed to be fixed. But you have all these do-gooders out there trying to fix problems that first of all they don't understand and they're not really problems. And so the solution to those problems actually creates another problem. A problem that didn't exist before. Does that make sense? Take for example this Stanley Cup. Did I tell you my Stanley Cup story? Now, when I say my Stanley Cup story, I mean the Stanley Cup, the hockey one. I do have a Stanley Cup story. I touched the Stanley Cup one time. I was a valet for the party where they had the Stanley Cup, and I don't think I ever told that story. I'm not going to tell it right now. But this Stanley Cup I have in my hand right here is a coffee cup. It's green in color. It's the Stanley company that's been producing the thermoses and coffee thermoses for a long time. My dad had a Stanley that he took to work, and I used to watch him take that sucker to work, to the workplace. He was a blue collar worker. He laid carpet. He was a mechanic, and he had a Stanley thing, and that was one of my first manhood associations was that green Stanley Cup, taking that thing to work and working hard. And I have one. And I have one in honor of my dad. I'm not blue collar per se. I do handyman stuff here and there. I helped my landlord yesterday fix something. But I'm a professor. I'm not primarily a blue collar guy, but I come from a blue collar family. So I proudly carry this Stanley around with me. And I don't know, a few years ago, I started noticing that places that sold Stanley, like Walmart, first of all, they stopped carrying it. I was like, what's going on here? And then secondly, I noticed that the Stanley company redesigned the logo and it looked worse. It looked a lot worse. Again, they were fixing a problem that didn't exist. It's a bunch of college graduates and they have nothing better to do than sit around and make busy work. And they get paid a lot of money for it. And it's disgusting. Solve real problems. Now, look, I understand it's a private company and people are going to say they can do whatever they want. They're a private company. They can do whatever they want. Yeah. That misses the point of what I'm talking about. I taught business ethics for over a decade, okay? In business departments. I'm business friendly. I get it. But there is a point to what I'm saying, and that is in business, in government, in culture, whatever, stop creating problems that don't exist that need to be fixed. It's a management bullcrap, high paid bullcrap. Let's get paid for bullcrap trend. And it's been going on for a long time. And it's at the heart of a lot of problems that we have. And it's a cultural thing. It's a busybody, busy work, bullcrap kind of a thing. And you know what? If you go to Walmart right now and you go to the sporting goods section and you look at the Stanley, they brought this back. And good for Walmart and good for Stanley. They brought it back and they're calling it the Classic Series now. Well, they brought it back because people didn't like the design. The new one was stupid. It didn't even make sense. No one even knew what it was. It looked like the Ruger bird or something. It's like, what? Hold on, is this Ruger? Am I buying a Ruger here without a background check? It was a Stanley. It was just ridiculous. So that's just an example. I have to give you examples. I don't want you to think that I sit up at night going Stanley and Cracker Barrel. I'm like angry, at night. It's more like I roll my eyes and it's just more of the same. It's creating problems to fix that are not really problems, and it's like there are real problems to fix. Focus on those. We're not teaching in college people how to identify real problems and really fix them. That's my point. And those are examples from the public sector. So you can tell me they can do whatever they want. They're public. You can do that if I'm not going to listen to you because you missed my point. Okay. I'm on page 11 at the top. Number one, Waiting Period Act burdens Second Amendment rights. Okay, this is the meat right here. Our first consideration is whether the Second Amendment's plain text covers the conduct curtailed by the enactment as informed by history. If it does, the Constitution presumptively protects that conduct. Common sense, ooh, 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 yeah. Notice he's saying common sense is a source of law here in overturning the legislature, in overturning the Democrats, in overturning a majority. Common sense dictates that the right to bear arms requires a right to acquire arms, just as the right to free speech necessarily includes the right to acquire a printing press, or the right to freely practice religion necessarily rests on a right to acquire a sacred text. Legal interpretation follows that common sense. How refreshing. By the way, Republican, just pointing that out. When a text authorizes a certain act, it implicitly authorizes whatever is a necessary predicate of that act. That's from Scalia and Garner, Reading Law, the Interpretation of Legal Texts. It's a great, great book. The Constitution has carried such a construction throughout our nation's history. These are great texts, great quotes, but I'm going to skip down a little bit. I'm on page 12 now, okay? He's quoting the Federalist. He's citing Thomas Cooley. I want to give a shout out to my former colleague. I just saw a picture of him the other day with John Boswell and Michael Ullman there. Scott Waller, Biola, Darren Guerra, Biola, also a guest on this podcast. Angus, not Angus. Crap, what's your last name, buddy? Angus. Anyway, he wrote his dissertation on Thomas Cooley, Claremont. It'll come to me in a second. I know two Anguses, and I always get them confused. Um, but I guess that's better than not pronouncing the G, because I used to think the G was silent. So I would say anus. Your name is Anus, right? Um, when I used to go to Black Anus restaurant, and they corrected me, and it was a little embarrassing. But I just I thought it was like Gnostic, the G silent. Anyway, um, as paper or computer is necessary predicate to the right to print, or the ability to own property is a necessary predicate of the right to just compensation for a taking. Acquiring, purchasing, possessing firearms is a necessary predicate to keeping and bearing them. Makes sense to me. On page 13, New Mexico argues, however, that the waiting period law does not implicate the ability of anyone to keep and bear arms, at least not directly. Instead, it argues that firearm possession is distinct from firearm sales and transfers. According to New Mexico, the Second Amendment's plain text does not cover acquiring or purchasing firearms, especially immediate acquisition of purchased firearms. Yet New Mexico acknowledges that severe or abusive limitations on acquisition would burden the Second Amendment, and that the waiting period here survived because the burden is minimal. So, by New Mexico's illogic, a restriction on firearm sales does not burden the Second Amendment until it does. That's good. The argument provides no limiting principle. See, this is always the problem. This is always the problem. They're making stuff up. They're making it up. It's just made up. They're making stuff up, and it's always for now. It's minimal. Yeah, but for now, maybe I don't think it is though. It's not even minimal right now, but this is just your first step. You want to do more because this shows how you really feel. It's just like the strong-willed child. You try to push that boundary and then you want more. And then you want more and you want more and you want more and you want more. You have to stand up right away. It's like the first day of class with the syllabus. You have to show them the syllabus. Otherwise, they will ask for an inch and then later they'll take a mile. It's the same with property management. We did property management for many years. When we were clear, we managed property with undergraduate girls, as it turned out. And that first year that I did it, I recruited the girls. I found them and I did the ad and all that. And I interviewed them and I got them in there. And we're still friends to this day. In fact, two of them came on the podcast, Jessica and Carrie. Carrie now teaches at the U.S. Air Force Academy. She was one of those girls that we managed. She's now teaching at the Air Force Academy. And we had her when she was an undergrad. I managed the property. That's how we became friends. And then Jessica Wilkinson, who came on twice to talk about home-based education. She came on as a co-host the second time to help me interview Tuttle Twins founder Connor, who actually reached out to me. I didn't even try to get him on the podcast. He tried to come on the podcast. Good for Connor. And I mean, the guy has sold like 5 million copies of his books. Mormon guy, really nice guy, awesome guy. Loved my time. But anyway, Jessica and Carrie both came on the podcast. That first year or two, it went fine because there were limitations that were they knew who was in charge. After that, I think that the landlord that we worked for made a mistake and they started trying to kind of get in there and recruit, and the waters became muddy after that. And because of that, they weren't clear who was in charge of the property, and then there were problems because we saw these are Christian girls, Christian undergrads, and if they did not have clear guidance at the beginning, it usually did not go well. And I'm not saying it was a disaster. I'm just saying it was not pleasant. Unlike the first year where I had control of that whole thing. And I still do property management. I see the same thing in the church context. I manage the property for the church and we have a tenant and there's boundary issues. And I'm just saying it's human nature. It's these boundaries have to be asserted and you have to be clear. And this is what's happening here. The Republicans on the 10th Circuit are saying your legislation is lacking common sense and a limiting principle. It's revealing what you really think about this constitutional right, and you think it's just going to stay there, but you're saying that, and we have to just take your word for it. And we don't even want it to stay there. We think you went too far even initially in your boundary crossing. But now we know that you probably want to go further. Probably. That's how it goes. I mean, just look at the United Kingdom. Look at Britain. Look how crazy they've become. We see where the writing is on the wall here. Okay, we're standing up to this, and this issue of the burden is minimal. Okay, Rebecca Scott, one of the plaintiffs. Let's say she gets attacked the very next day and she needs that firearm. Is the burden minimal for her? Let's say she gets attacked and she gets seriously injured or killed, or a loved one, or her neighbor, or some third party, innocent third party. Is the burden minimal? I think you're taking a lot for granted to say the burden is minimal. You can see the future. Is that what you're saying? Trust us, the burden is minimal. We know what tomorrow looks like for you. They're just making stuff up. And the Republican is saying, you're making stuff up. This argument provides no limiting principle. It inevitably leads to case by case judicial interest balancing. But the Supreme Court and the Constitution reject the notion that a right should be restricted simply because the government believes its interests, on balance, are more important than the individual's. Let me read that again. The Supreme Court and the Constitution. I love how he said that. Are you hearing what I'm hearing? The Supreme Court, oh, by the way, and the Constitution, they're not the same thing. Reject the notion that a right should be restricted simply because the government believes its interests. Whose interests? Its interests, on balance, are more important than the individual. Well, of course they believe that. That's why there's a case or controversy. If they didn't believe that, there would be no two parties in the case. There would be no case at all. It would just be individuals on the same side. Yeah, makes sense. Here's a good quotation from Heller. The very enumeration of the right removes it from the judiciary's power to decide on a case by case basis whether the right is really worth insisting upon. I love that quote. New Mexico's argument that limitations on firearm sales or transfers do not implicate the Second Amendment's text, plain text, is wrong. And the district court's engagement in limited means and scrutiny is also wrong. The district court's analysis, crediting what it saw as a minimal burden, circumvented Heller, Bruin, and Rahimi. By the way, all Republican decisions. Landing right back at the freestanding interest balancing approach that those cases explicitly rejected. Wow. Powerful. Um, Here's a quotation. Judicial deference to legislative interest balancing is understandable. It is not deference that the Constitution demands here. The Second Amendment is the very product of an interest balancing by the people, and it surely elevates above all other interests the right of law abiding, responsible citizens to use arms for self defense. And not when the government says you can. Okay. Not like after 7 days, but like right away. Another court also faced with the assertion that keeping and bearing did not include acquiring when considering a waiting period law post Bruin Rahimi also rejected the argument. It stated, if a citizen cannot take possession of a firearm, then his or her right to possess a firearm or to carry it away is indeed curtailed, even if, as the state claims, the curtailment is modest. However, the threshold inquiry is whether the Second Amendment covers the conduct curtailed by the act, not a qualitative assessment of how modest the imposition on the right happens to be. That is indiscriminate dispossession, plain and simple. That's a good quote. A blanket waiting period prevents a citizen from possessing a firearm for a flat period and is an infringement on the right to bear arms. It must be scrutinized as one. Bottom of page 14, top of page 15 now. The burden imposed by a cooling off period is brought into sharper focus when considered in the context of other constitutional rights. A carte blanche 1 week cooling off period to publish news stories, unconstitutional. Temporary closures of churches during COVID 19, unconstitutional. If a criminal defendant had to wait 30 days after his arraignment before he could seek legal counsel so that he would not unduly resist his prosecution, unconstitutional, of course. The Second Amendment is no different. As a general matter, the government cannot delay the exercise of a right because it believes that citizens might misuse it without sufficient time to reflect beforehand. That's quoting Sylvester versus Becerra, originally Sylvester versus Harris. That's Kamala Harris. And that's Thomas dissenting from the denial of cert. We did a whole episode on that exact thing, which you saw on the screen. It showed up when I searched Ishii, Ishii, on the Republican Professor on YouTube. Our law rarely generalizes the potential for abuse. It requires an individualized assessment. In short, regardless of paternalistic intent, waiting periods burden the right to keep and bear arms. Wow, all that just to say what you already know. um, we're on the top of page 16, and I'm going to scroll down and just see how much longer we have here. Or whether I want to do that now or whether I want to do it later. I think I'm going to stop for now. And I'm going to end with a brief story of an exchange that I had because there was another murder at a Catholic school by, it looks like the murderer. Notice I'm not using the word shooter, and that's on purpose. Shooting has nothing to do with the morality or even the legality. There's no presumption. Shooting happens at shooting ranges, it's legal. Shooting happens in self-defense, it's legal. It's moral. Okay, so I'm not using the term that is ambiguous. I'm using a clear term, murderer. The crime is murder. And it seems like I always get this with my students. How do we solve shootings? Well, I always say this. I think what you mean is, how do we stop murder? I think that's what you're asking. And notice how I switched the language, made it clearer. When you go to a shooting range, you're going to hear lots of big noises, and no one goes, how do we solve these things? You go hunting, you hear a crack of a rifle in the distance. I grew up big game hunting, elk, Colorado, small game hunting. No one goes, how do we solve this? Shooting is not something to be solved. I'm being, this is called political phenomenology. I'm just describing the term. It doesn't mean something that's inherently immoral or inherently illegal. Murder, on the other hand, is a much easier thing to get your mind around. This was murder and attempted murder. It's also damage to property. Now, that's something to be solved. Yeah. How do you stop murder? Well, people have noticed a long time ago that if you fight back, that's one way. I mean, back to, you guys see this? I go back to basics. I shared on Instagram Babylon Bee's meme that was taking the clue game and saying that liberals have come up with a new clue game where there's no perpetrators, there's just weapons. And so you're not trying to find out who used the weapon, you're just trying to find out which weapon did it. And I had somebody push back on Instagram and say, accessibility of guns is part of the problem. Okay. So I got back to this person and I said, accessibility of credit is part of the problem of credit card fraud. You got to distinguish between part of the problem, meaning analytically, and the source of the problem, right? Accessibility of alcohol is part of the problem of drunk driving. Accessibility to vehicles is also part of that problem. Analytically, you can't understand the problem without these parts. I go even further. Part of the issue with vehicles is gasoline, accessibility to gasoline, electricity. But those are not the sources of the problem that we're talking about. When you're talking about criminal conduct, the source of the problem lies elsewhere. See, this is back to basics. Back to basics. That's why I use the term murder. How do we stop murder? That's the issue. That's criminal conduct. That's real criminal conduct. We don't stop real criminal conduct by inventing new crimes that criminalize innocent conduct and create victims where there were just innocent people before, that blame victims of real crime. Thanks for joining me on The Republican Professor. I'm been your host, Dr. Lucas J. Mather. Today is Friday, 29 August, 2025 years after Jesus. We're going to get to presumptively lawful conditions on firearm sales next time. It'll be a shorter episode next time. We'll see you next time. Take care. God bless you. All right. How'd that go? Yeah, great. What do we got? What's the next one? Is that VA click case? What was that VA case called? From it was March 2020. Okay. Um, so Gorsuch was in dissent, or did he write the dissent there? Jackson wrote the dissent. Ooh, yikes. Okay, but Gorsuch joined it. Hmm. Yeah, that's definitely something we got to talk about. I don't not we're not going to do it next time, but make a note here to what page was that we stopped? 19? 16. Stopped on 16. All right. So when are you going to post this? I just want to take a look at the um how you're labeling it on the file. Yeah. No, I'll have the description up pretty fast. I'll just I'll take it out right now. Yeah, I want to get it up now. Hmm. Well, I was gonna read that decision tonight when I'm having a cigar. I got a new whiskey I'm gonna try out. It's a Kentucky bourbon. It had 95 points, so um it's really hot out, so I will do it probably when the sun's going down, and I will take a look at that case, and then we'll have that ready to go for September, maybe October, depends. I have a Tennessee trip coming up. Yeah. Appalachia. I forget what the name of the city is. Flying into Nashville. We're driving over. Um, okay. Did that make sense? Good. Yeah, the back to basics thing, I think we're going to keep going back to that. It's the same with grade inflation. It's like back to basics. Sit the kids' butts in their seats, get rid of the notes, get rid of the devices, make them read. Yeah. Yeah, I know. They'll get better. They'll get better over time. Yeah, but if you don't do it, we're messed up.